The Valley Current.
Hey, Myron, you got a nice campground behind you there.
Yeah,
That's beautiful.
that's the Eastern Sierra, where I used to go hiking and fishing all the time. How you doing? You in Florida?
Yeah, we did something pretty unique. We went camping, and the campground, I didn't realize until it was too late. It had these fire ants, and I was walking barefoot
Oh boy.
like an idiot, of course. So of course I got all these fire ant bites. But
Oh,
the interesting part these days with all this AI is you can take a picture of the bites and
yeah.
send it into one or more AI tools. We used about 7 different tools.
I think that's a Southern phenomenon. I don't think we have those around here.
I think it's in Texas too. My wife is from Texas. She said, "Oh man, I've gotten those bites before. You were an idiot.
Oh boy.
Why didn't you put your shoes on?" I said, "Oh, I wanted to feel the grass. That was pretty stupid,
Yeah.
pretty dumb." So you've come up with something really interesting. You've come up with a way to review other people's briefs. So most lawyers don't want to do that because they kind of feel like you have to rewrite stuff and you get into a big fight over it. But I looked at your website and you've got a big announcement, said, wow, there's a guy with 60 plus years of experience and he's willing to look and read and critique and probably rewrite other lawyers' briefs. I have to tell you, that takes a lot of guts because you could look at a lot of stuff.
Like
Yeah,
I've been doing that type of thing off and on for years. People have called me and asked me to do it once in a while.
right,
I've never focused on it. And what got me to focus on it and make it like a separate page on the website and
right.
some time and energy into it is a couple of things, Jack.
Mm,
One is I wrote an article for a plaintiff's magazine, that's what it's called, uh,
okay,
these are lawyers who do PI cases, employment, and
right,
and I wrote a piece on appeals for them, and they put me on their mailing list. So I get the magazine every month, and
right,
I find it really interesting because they always have articles that get into specifics on trial tactics and
right,
how to cross-examine an expert, how to
right,
talk to a jury about money, things like that. And they're very well done, very carefully done. And these guys have experience and they share it with their fellow plaintiffs' attorneys. And it occurred to me that there's nothing like that for brief writing, either on appeal or at trial court. Nobody does that. Uh,
right,
I think, excepting me. I mean, I wrote this book for CEB on strategies on appeal, which is all about the intricacies of different things you can do, which I'll talk about a couple examples in a minute. But
okay,
appellate lawyers don't talk about it. They don't have a magazine like what those guys have. They do communicate and they talk about appeals in various courts. And there's books on how to do appeals, mostly by appellate judges who write
right,
on how to make their lives easier, how lawyers
right,
write briefs that make it easier for them to read, which is
right,
helpful. I mean, but that's only a piece of it. That's only
right,
part of a strategy. And I'm built as a fighter, and I think of strategy, and that's just the way I am. But nobody else does. And
right,
these trial lawyers who put so much time and energy into cleverly thinking about how to handle a witness, a jury, they don't put any time into how to write a brief. And
Well, they don't even put in time thinking about how they have to protect the record on appeal. Let's get some more
right,
fundamental, right?
right, that too. But of course, the best thing my trial lawyers can do for me on appeal is win at trial. Make me the respondent. All
The
right.
odds go up. The odds go up by at least 80%, just right
Yeah.
then and there, right?
Yeah. So if I can help them win a motion for summary judgment or a post-trial motion, I'm adding more to the case than anything I do in appeal.
Right,
Win the goddamn trial. And
right,
a lot of people want to handle their own appeals, and that's fine. And I think I can increase their chances of winning from my experience. The other thing that really hit me is there's a young lawyer with a big firm. I'm not going to mention his name, and he's with their appellate department, and
right,
he's one of the stars of their appellate department.
right,
His credentials are impeccable. He went to Harvard. He clerked for both a federal district court judge and an appellate judge. And he happened to like my columns in the Daily Journal. He contacted me. We talked, and he asked me to help him. I said, sure. Show me one of your briefs. He showed me one of his briefs. And from one point of view, it was very well done. Good case research, very carefully done on the facts, but he had no sense of strategy at all. None. And
right,
I was surprised. He didn't learn it in law school at Harvard. No one taught him strategy on brief writing because
right,
they don't do much of that. Nobody in his firm had done it. And he had to go outside his law school and his firm to come to me to help him with it. And I did help him with it. And I figure if somebody like that needs help with strategy and brief writing, probably everybody does. And uh, I spent a lot of years teaching, so it really fits with my skill set, teaching lawyers how to write briefs while
right.
working on a real case. See, I lecture on this stuff when I talk to bar associations, but that's all abstract. It's not
Hmm.
hands-on real. And this gives the lawyer a chance to work on one of his cases and have me help him improve his skills and improve the brief and serve the client and have a
Right,
chance of winning. So
right.
it's a good combination. Let me give you a couple examples of what I'm
Okay,
talking
okay,
about when I talk about strategy.
okay.
Um, every brief I read, appellate or trial, has an introduction,
Right,
and the rules do not require an introduction. And somehow the habit started, and everybody copied. Everybody's got an introduction,
right,
and I rarely see one that's any good. Rarely. Most of them are unintelligible and annoying to the judge.
right.
And
Well, there's a lot of throat clearing that's unnecessary, total throat clearing, right?
yeah, yeah. What they do is start with the assumption that the judge knows about the case, which he
Right,
doesn't.
right,
Appellate judges know zero when they start reading the appellant's opening brief. Trial
right.
judges usually don't know or don't remember. So they talk as if the judge knows and the judge doesn't get any of it. And they go
Yeah,
on and on. I mean, an introduction should be no more than about 3 pages. They'll go
right.
7, 8, 9 pages.
Ouch.
The thing they do is present a rant. It's usually a rant against the trial judge in appeal. It's against the other attorney in trial. Judges don't like rants against
Yeah,
people like that,
right,
unprofessional.
right,
So they start their brief by annoying the judge.
right,
And once the judge sees what's going on, he just stops reading it and skips.
right,
So
right,
I don't do that. I write an introduction that is persuasive. I want to win the case with the introduction. And
right.
usually that means presenting enough of the facts to show the judge that the trial judge was wrong and maybe a little bit of law, sometimes none, and just hit them right between the eyes. This is why you got to reverse and keep it. I can do that in 3 pages in most cases. There are cases where I can't do it because the record is so complicated. I got to make a fair presentation of the facts, and I can't have a fair one and do it in those 3 pages. When that's
Right.
the case, I'll have a very short introduction, enough to tell the judge the issue. So when he reads the next part of the brief, the statement of facts, he'll have some understanding of what he's looking for.
Right.
I might have a summary of argument after the statement of facts that gives the argument. But
Right.
we try to cram all this in the introduction, which could be a dozen pages. And no, it's got to be limited. So that's the kind of thing I'm talking about. And
Right.
nobody teaches that. It's not in any of the books. Another example is what I call the bad guy phenomena. I'll have a case where on the law, the trial judge clearly made an error and there should be a reversal. But there's
Right.
a problem. The problem is my client is a jerk, and
Right.
the record shows he's a jerk. He lied on the stand, he cheated somebody or something. And
Right.
my experience is they usually lose. And how they lose, I've seen all kinds of acrobatics by appellate
Yeah.
judges to make them lose.
Right.
They ignore facts, they twist the law. These are all unpublished, of course, so the Supreme Court won't take them. And
Right.
I've always looked for a way around that. And I happened to find a study done in your base, New York. It was a big
Mhm.
conference, 1,500 judges. And these law professors got permission to conduct a study of the judges. And what they would do would give them a hypothetical set of facts involving a question of law.
Right.
They give the facts, but they gave 2 sets of facts, one to one group of judges, one the other. In one set of facts, the plaintiff was a jerk. In the other, he was a good guy. Made no difference to this question of law. But guess what? It did make a difference.
Right.
Like 20, 30% of the judges would rule against the bad guy more than the good guy. And
Right.
it was living proof that judges do this. So I got to get around it. How do I do it? I just won a case in the Court of Appeal in LA where my client was right that demur was sustained when it shouldn't have been. Um, but he had a bad record. He'd been in front of this appellate court over a dozen times with some weak writ proceedings and appeals, and
Right.
he was this far from being declared a vexatious litigant. And
Right.
the trial lawyer who called me said, I think it's a good appeal, but the optics are terrible.
The
Well,
optics. The optics. That's
I
the key
let
word.
off
The optics.
brief in the introduction. I discussed this New York study I mentioned.
Mhm.
And I said, some judges do this. Now, I didn't take it to the next step and say, don't you do it.
You
But
didn't need
that's
to
the
do that.
obvious message.
Yeah.
And
You didn't need to do
do it.
that. Right.
So I don't know if it was what I wrote that influenced them, but they did the right thing. Even jerks are entitled to justice, right?
Yeah. Yeah.
And
Yeah.
so it's things like that I'm really into, I really care about. And it's all for a good purpose to get justice for my clients. And I want to help other people do that too by thinking strategically. Don't just, go through the motions. Don't just assume I'm right on the law, I should win. It's not that simple.
Right.
I think I know a lot about that stuff. My own win record is pretty good. So I'm looking forward to get some people calling me to help out on
Well, tell me how it works, because I've seen some lawyers, really they're gig lawyers, say, look, I can kind of help you. And they do kind of an AI approach where there's really no human involved, and they charge a very small fixed fee. Like they might take a brief, and they're essentially doing editorial work, typo correction, that sort of thing. You're doing something far different. But these lawyers are like, oh, you give me this and I'll do for $1,000. I'll really make sure it's polished. I'll make sure the grammar's right. I'll make sure the sentences are right. And that's really kind of like secretarial or clerical work. They use a bunch of tools, automation tools to do it. Maybe they improve the brief a little bit, but you're really talking like, really, I think, in a way, because you're calling this the brief doctor, meaning like, the doctor of science of dealing with the art and science of dealing with briefs. And you're saying, look, you need someone to look at this surgery before you patch up the patient and send the patient home. You want to actually make sure that what's there is the correct procedure, the correct substance, the correct argument. So how do you price something like that? Because there are a lot of people that think, oh, if I send it, maybe, someone spends an hour and they're a brain surgeon. Okay, they charge me for an hour. That's great. I get their brand. Maybe I get their malpractice insurance. I mean, you got to imagine what people go through people's heads of why should they spend more money. But how do you fix a charge? Because I think when you do work like this, it's project work. People don't expect to pay a full tab for what might be a pretty enormous process, right?
Well, I don't know, Jack. I haven't thoroughly worked that out. Normally, I do charge by the hour and I get a
Right,
security deposit.
right.
Uh, but normally I spend 50, 60, 70 hours on a case, maybe
Not
a
trivial.
big one.
It's
This
not
won't be
trivial.
like that. No,
Yeah.
I can do most cases that we're talking about between 5 and 10 hours. So it's not, and I'm not doing the kind of band-aid and detail work you're talking about. I'm looking at, what can we do to make this a winner? Um, you,
Right,
you,
but do you get what my worry is, or my concern really on your behalf, just generally and maybe generically. You get some lawyer that thinks I'll get AI to write a 25-page brief, and some AI will write a 25-page brief. It may have a bunch of hallucinations, miscitations, misquotations, lots of shit wrong. Then they send it to you and say, okay, here's a budget. I get $5,000, turn it into a great brief. And you do a great job on the prose, but you don't go back and read every case, cite every case, shepherdize every case. Maybe you will, I don't know. But somewhere in this,
no, I'm
you
not doing that. No, that's
right.
not what
So
I'm offering. Uh,
no,
I'm,
no, no,
I,
no. I know. But you tell me how you get off from someone then pinning the blame on you when the court says we found 5 cases that were not correctly cited or the quotes were wrong. You got to have a really big disclaimer in your contract to say, look, I'm doing strategy at a high level and I'm not doing grunt work. The grunt work should have been done by some associate who's really got eyes on the brief, right?
yeah.
Eyes on the citation. That's what I worry about because I think a lot of lawyers think, oh, if I hand it off, let me tell you why. I get these calls all the time and they say, well, we want 3 things from you. Number one, we want you to argue the appeal. We've heard you. We've heard your podcast. We like your voice. We want you to argue the appeal. Can you make it to wherever, where, New York District Court, New York Second Circuit, wherever? Can you make it there? Then they say, number two, we obviously want you to read the brief we're working on. We're working on the final reply brief. Let's just say that's the case. I'm like, well, okay, how much can you do with a reply brief? And then they're like, don't spend too much time on it because the work is fundamentally done. But if you think we could improve it, yeah, you get my point, right? You're getting it. And then they say, and number three, we really want you to put your name and your certification and your, appellate specialist stamp, all that jazz on it to be like co-counsel. And I didn't even do the opening brief, and I don't have the whole record on appeal. You know what I'm saying? And then they say, by the way, we really don't expect to spend. We'll cover the travel and the lodging. We don't expect to spend more than $5,000. And I just look at that like life is too short. Maybe if I was a kid, 3 years out of law school, maybe I would think about doing this. Probably not even then. Of
Hey,
course, I
Jack,
was. Yeah.
this is all your fault. You built yourself into a celebrity, and that's what they're buying.
You're
Your
funny.
celebrity. Okay. And
That's too, that's
I
too,
don't,
that's too,
I do
that's
have
too
that
kind.
problem
That's
once
too
in a
kind.
while,
You
but
have it. You're a
I don't
celebrity as
like
well, Myron. You're a celebrity as well. You're more of a celebrity than I am. No,
it.
seriously. To me, the problem that exists is that people don't understand you get what you pay for. And they don't want to pay for it and they want to get. And you have this ethical obligation that is getting worse and worse, particularly for local council and co-counsel are getting tagged left, right, and sideways with sanctions for not picking up shit that other people file. And to me, that's the risk. Now, if you can contract around it, insure around it, I suppose, to some degree, I don't know. I mean, it's the only thing I thought of when I thought of what you're doing. Man, I hope you don't get whipsawed by this. I hope you don't get surprised by some of the nutty stuff because you're going to read some nutty stuff, I'm sure. And you're going to say, this guy's lost this appeal. How do I break the news to him? What do I tell him? I got to rewrite this. This is a $50,000 project. He doesn't want to spend $50,000. Maybe the case is not even worth $50,000, right? You don't know until you get your arms around it.
Well, you're right, Jack, and I should be careful because I don't want to get involved with people who just want that kind of you know service at a discount and just use my name. And no, I think I have something to offer that's real, and I think who people who think the way you're talking about have a misconception of how appellate judges decide cases.
Right.
I don't think the reputation of a lawyer has much to do with it. If the lawyer either did a good job and the record supports what he's saying, or it doesn't, and I've seen little nobodies beat big firm lawyers, if they're right. And
Right.
so I don't think it works that way with most judges. Um, so I'm not too concerned about those things.
I
I,
mean,
I just want
I think other things you do that add a lot of value, like when you do the mock appellate panels with yourself and a couple of the appellate justices that you have on your panel, because you've got a team that's got like 1,000 years of experience. Really, it's a huge amount of experience. I'm jealous of it, to be honest. I think that's great that you have all those folks. They really can hear an oral argument. They could say, "You're not impressing us." And there's no liability, right? Because you have the opposing counsel or the counsel make the argument, and you just maybe do the opposing lawyer, or maybe you just act as one of the judges, and you say, "Look, it's not landing. You got to change it. It's got to be. You got to get rid of all the throat clearing, even the stuff." Do you ever listen to the stuff that's on the Supreme Court channel? I listen every once in a while to the cases that are before the U.S. Supreme Court. They have like a live radio feed or a
yeah,
live feed that comes up. Some of this stuff is really terrible. These people are even really big, great firms. They don't land the point, and now they allow the advocate to get 90 seconds up front before they start popping them with questions. And I tell you, that 90 seconds has got to have different ways to hook into questions, and they don't even realize it. The 90 seconds tends to be kind of a waste of time. They
yeah,
lose the whole ability to set up their argument.
yeah.
So it's an interesting problem because, law school, I mean, I was on the moot court, I was on the law review, but law school doesn't really train advocacy. It
No,
doesn't. Maybe they're starting to, but you're at a law school that probably trained a little bit of advocacy, right?
yeah. I mean, I've been on moot courts at law schools, and I stopped. I don't like it. It's all about form. It's not about substance.
Right,
And
right.
I've also run a moot court for practicing lawyers, and uh, I don't waste a lot of time complimenting on their hairdo or their delivery. You're here to win the case. That's what
Right,
counts, and that you're not going to win based on what you look like.
right,
So
right.
that's my focus. And I don't really focus that much on the opposing lawyer because these judges are independent. They don't just choose the best lawyer or choose the best brief. They got their own ideas, and that's what
Yeah,
counts.
yeah,
If I get a flavor of the oral argument that they're against me, I try to dig out the reason and then turn them around, which is really hard. But that's what oral argument's for. They've already written the opinion. So what are you there for? To figure out what the opinion is if they won't show you a tentative and talk
Right.
about it. That's the whole point of it. And my reputation, my experience means nothing to them. It's what I can say on the spot.
Yeah. Yeah. Well, I love what you're doing, Myron, and I hope it really works to your advantage because I think you can help lots of lawyers in lots of different ways. And obviously, even if it's just, hey, I'll help you rewrite the introduction, because that's either going to get them to read the rest of the brief or not. Because I almost think to some degree you can parcel it like, hey, look, if you really want the $5,000 deal or $3,000 or whatever someone says, I'll look at your introduction and I'll give it a few hours of time and maybe I'll even rewrite it. But if you really want me to go through the whole rest of the friggin' record and the brief and a million other things that you do as a real zealous advocate, that's a different deal. That's a totally different deal. Because I tell you, people
I don't even want to do that. Let somebody
really,
else can do that. They don't need me for that.
mm-hmm.
I'm interested in the guts of the thing and help show them how to win. I've had lawyers give me an 80-page brief that is mostly boring, poorly written, not persuasive. But guess what? On page 53, they got a winning argument.
Right.
On page 53.
Right.
What if the judge is sleepy and goes right past it? Stuff like that, which I see all the time.
Right.
So that's what I'm offering.
Yeah, well, I think it's a good idea. I think people should contact you. I think you can add a lot of value and hopefully it works and you enjoy it. I mean, you are the one person that I know, frankly, that is still working after 65 years of practice. Do I have that right, Myron?
Who's counting, Jack?
You're not counting anymore, but you're literally are an aspiration. I really want to give you a lot of applause because you have stayed with the program and you clerked for Justice Peters, if I'm remembering correctly, on the California Supreme Court.
Yeah.
And he was a great justice. I really liked reading his opinions. He was great, and that court was great. And we're living in a totally different time now, so. We'll see what happens. Obviously, you should keep up all the great work you're doing. You're definitely going to make it to 100 years, maybe even 110. So bravo. Seriously. I'm going to send you something for you to read with your son. It's something I just finished that you might sit down with him, and your wife might enjoy it too. It's something I've been working on for a while. It's not legal at all. It's much more practical. It probably leverages more off of my MBA than it does my law degree. But you look at it and you see after reading the first chapter or so whether there's any real enjoyment that comes from it. You might look at it and say, yeah, this is crazy. But I think it's something that everyone.
Jack, I read your other piece on estate planning. It was wonderful.
Yeah, I think you would. I think
on estate planning.
Yeah, I want you to look at something that really is if my legacy exists in life, I give enough money to enough high schools so that all the high school kids understand what I'm calling the 7 essences or 7 quotients. You read it, you decide what you think, because I think you've got a lot of wisdom. And I think you might enjoy it, and your wife might enjoy it, and your son, who's what? How old is he?
Forward to it, Jack.
Okay, good. Take care. Thanks for spending the time.
Okay.
I'll send you the link. Take care. Bye-bye.
Thanks.
Sure. Bye.
Tune in next time on The Valley Current.